They convicted Karen Ellison of murdering her husband in 1998. Then someone found a recantation, a witness taking back sworn testimony, buried in a filing cabinet the defense never knew existed. So why did the district attorney's office sit on a document that could have kept her out of prison? The official story was simple, and juries like simple. Paul Ellison was found dead in the garage of his home outside Tulsa, struck twice with a tire iron. His wife Karen had no alibi for the window between 11:00 and midnight. Her neighbor, Diane Sorrell, testified she saw Karen outside at 11:40 hosing down the driveway. Prosecutors called it consciousness of guilt, a woman washing away evidence before police arrived. The jury took under 3 hours, life without parole. For 21 years, that was the file. Closed, cited, taught in law schools as a clean circumstantial case. Nobody went looking for what wasn't in it. In 2019, a records clerk in Tulsa County was digitizing cold storage, decades of case files headed for a warehouse in Oklahoma City. In a box marked Ellison Closed, behind the trial transcript, sat a manila folder that didn't belong there. Inside was a notarized statement, 6 weeks post-dated from the verdict, signed by Diane Sorrell. In it, she said her trial testimony was false. She wrote that she never saw Karen on the driveway at all, that she'd been at her sister's apartment across town until well past midnight, and that Detective Ray Mercer visited her 3 times before trial, each time rehearsing the same sentence with her until she could say it without hesitating. The document was notarized. It was never filed with the court. It was never sent to the defense. It sat in a drawer reserved for informant files requiring supervisor sign-off that, as far as any log shows, nobody ever requested. Here's where the trial record and the drawer stop agreeing with each other. At trial, Sorrell's 11:40 citing was the single piece of testimony that closed the 20-minute gap prosecutors couldn't otherwise explain. The gap between when Paul's business partner left the house and when Karen called 911. Without Sorrell, the timeline has a hole in it big enough to fit reasonable doubt. With her sworn recantation, that hole reopens, and it reopens directly against a sister's apartment 40 minutes away, a location, incidentally, that phone records already placed her at, though nobody at trial connected the two. The prosecution's closing argument called Sorrell the only neutral witness in this case. The recantation calls her the most manufactured one. This should have surfaced within weeks of being written. It didn't, because of where it was filed and who controlled that filing. Under Brady v. Maryland, prosecutors are required to turn over evidence favorable to the defense. That's the chain of custody obligation nobody in this case honored. But the recantation wasn't logged as case evidence. It was logged as a confidential source document, a category that in 1998 Tulsa County required written authorization from the assistant DA supervisor to release, even to appellate counsel. That supervisor was Thomas Rays. Rays left the DA's office in 2001 to run for county commissioner. He won. The folder stayed exactly where it was for 18 years, technically compliant, functionally invisible. But the recantation wasn't the strangest part of what was in that drawer. Behind it was a second document, a property log for physical evidence from the Ellison scene, initialed by Detective Mercer, showing the tire iron itself was checked out of the evidence room for photograph reprocessing 9 days before trial and returned 4 days later with no photographs on file. Remember the driveway hose story Sorrell was coached to tell, the one meant to explain washed away evidence. Mercer's own signature now sits next to an unexplained 4-day gap in custody of the actual murder weapon. 2 years after the Ellison trial, Mercer was investigated, not for this case, but for tampering with evidence in an unrelated narcotics prosecution. That investigation ended quietly, no charges, and his personnel file was sealed by the same county that sealed Sorrell's recantation. If the recantation is true, Karen Ellison has spent over 2 decades in prison on testimony a detective built, and a prosecutor's office buried rather than disclosed. Rays benefited, a clean conviction on his record heading into an election. Mercer benefited no scrutiny of a missing 4 days with the murder weapon. Karen Ellison's appeal, filed in 2020 based on the discovered folder, is still pending review by the state attorney general, who has neither confirmed nor denied whether Mercer's sealed file will be reopened alongside it. Nobody has explained why a sworn recantation, addressed and notarized, never once appeared on a single court docket in 21 years. Nobody has explained the 4 missing days with the tire iron. And nobody, not the AG's office, not Ray's, not Mercer, who still lives 40 minutes from the courthouse where he testified, has said, under oath, what actually happened in that garage.